we need to protect and serve our community, especially people with Down syndrome.
So we want to be approachable. We know that lawyers have a tendency to get a bad reputation. Sometimes it is earned, girlfriend. We really welcome questions. We think that your questions will free the neighbor. Your neighbor wants to know, but feels a little more timid. So feel free to ask us anything. And I sat through the session that preceded this, and a lot of the faces are the same, so I imagine that you are just full of all kinds of legal questions. So we do have our own agenda of what we thought we would talk about, but if you have other questions and you want to interrupt, unless you're completely wild, I will answer them. Or we will take our turns in answering them. So the big topic that I thought we would address today is, do you need a guardianship? Do you need a guardianship? You all are here because you have a connection to an individual with Downs. So the question is, everyone says we need one. When do we need one? Do we need one? So I thought we would divide this up in that we could have Lisa give us some information about power of attorney, and then nuts and bolts of when do I do it, where do I go, what do I need, how does it work? We'll hit Nikki with that. Sound fair? Okay, any of you already done this? We have an expert in the room. Well, we do have an expert in the room. If you've already done it, you know. So Lisa, why don't I let you lead off?
Sure. So how many people in here have your own powers of attorney documents drafted? Good. So we're often thinking, do I need those for my child? And if you feel that your child has capacity and understands that saying it's okay for mom and dad to handle my finances, it's okay for mom and dad to speak to my doctor and make medical decisions for me, then absolutely you can do those. And those can be used in conjunction with a guardianship. So if just some general information for everyone that may not have one or may have some misconceptions about what they are. So you'll always hear, I'm the power of attorney, or I'm my mom's power of attorney. Those are for while you're living. So if you have older parents and they have named you as their power of attorney, that stops upon their death. That does not carry on through. That's when a will or a trust or some sort of estate planning document would come through. So I always think that that's a common misconception, that people think that that gives them power to manage property after someone passes away, and it does not at all. So there's really two kinds. There's one over all your business things, your money, your bank accounts, your safe deposit box, your real estate. That is called a power of attorney for your finances. And the word durable, you'll often hear that in a document. That means it survives beyond your incapacity. So I draft a power of attorney document appointing my oldest son as my agent, and then I become incapacitated later. That document is still valid. So you'll often see sometimes the ones that are, we call them springing. We don't really do those much anymore, but oftentimes someone would draft a power of attorney document that says this doesn't become active until I'm incapacitated. So we always say, if you don't trust someone now, while you know what's going on and can kind of be minding the store, why would you trust them when you're incapacitated? So we don't draft those ourselves anymore.
So Lisa, what would you tell them is the magic age for them to get your power of attorney?
Everyone over the age of 18 should have one.
So what happens if they are the parent of a child, and the day they hit 18, what rights do they have over that child?
None. And I know that's really hard. I'm a mother of 4. And I said, well, you know, I still do their laundry. How can I not get into their bank account? But it's true. And I just kind of experienced that myself with my 20-year-old had to have surgery. And I have to get him to log me into his MyChart, even though I'm paying the bills and making the appointment and giving him his medicine, all those things. So I actually Had him come in, had one of the other attorneys in our office draft a healthcare power of attorney and one for his finances. But you think about it, you know, once you're over 18, you, again, like Samantha said, you have no rights to your child's
I just don't
information.
understand, because I really don't think 18 is a grown-up age anymore.
No.
I got a call this morning. I'm getting ready, trying to decide what lipstick to wear. And my sister says, don't forget, called me, my youngest sister. She said, don't forget to call Zoe today. It's her birthday. How old is she? 18. Now, you have no idea. This gal has everything that her mother thinks she shouldn't be doing. I said, what's she doing today? Getting a tattoo. She said, her dad and I offered to pay her not to. But she's 18.
Yeah.
I'm just saying. So 18 in my mind was a mature age.
Right, so exactly, same with the doctors.
So these are neurotypical, you know, and there's no magic age. As my oldest is now 26, I don't think he's particularly able to make decisions. I'm just saying, there's no magic age. They're always going to be our kids,
So
right?
you're saying our adult children that don't have a disability need a power of
Yes,
attorney?
absolutely. And yes.
Why?
Well, I'm sorry, Lisa.
We get all excited and we all want to jump in. No, so I might think about this myself. So my child is away at college. He's had a job. He has a bank account. He's in some sort of accident and can't communicate at all. He has bills coming due. He has a lease. How am I going to manage that for him? The bank's not going to let me into his account. I can't even get into my 16-year-old's account. She lost her debit card, and the bank said she had to come with me. I had to go to the bank. So you need that in the event something happens, that you need to manage your child's finances for them, whether it's temporarily or for the long term. The same with their health care. I mean, you're their mother.
So like my husband and I should have
Well, yeah,
Absolutely.
Nick, so Nikki, had a situation where we had a married couple, like you're saying. He has a stroke, goes to KU, and what happens?
Technically, the wife doesn't have any authority to do anything. Even though they're married. So that doesn't give you the legal authority to make decisions for your spouse. And then the only access to money you would have are accounts that are joint or in your name. But you wouldn't, if something happens, well, in that case, like she couldn't go and get a distribution from his retirement account or handle anything that would require both signatures or was just in his name. And that can lead to a lot of unintended consequences.
So spouses should have each other listed? Yes.
Well,
That's
if you
the
trust
most
him.
common thing.
That's a good one.
And I'm running into a situation. I met a woman whose mother never did executed powers of attorney, and she wants to be able to, her mother's in a facility, and she wants to move her mother to another facility. She doesn't feel like her mother's getting good care there. Her mother now can't communicate, and she doesn't have powers of attorney, so she's probably going to have to take steps to maybe get a guardianship. It's a lot more expensive and a lot more time consuming, and then each year there's an annual reporting to the court, so there's a lot more things involved. Well, sometimes the guardianship is absolutely necessary, but had her mother, when she did have capacity, just executed a simple healthcare power of attorney, then her daughter would be able to make the decisions that she feels like are best for her mother and also carrying out what her mother's wishes are.
I raised that situation, the example of the spouse, so that I could ask Nikki to explain to us. I thought that was, I got a noise like that above my bed this morning. I think there's a creature in the house. A little rat or something. That's recorded, right? So Nikki can tell us what the process is like, the same process that if your spouse has a stroke and you need to be able to make decisions, is the same process called guardianship. So tell us about that.
Okay, I missed the cue.
No, I didn't.
So for guardianship, so for our lady whose husband has had a stroke, the only way for her to be able to do things financially or medically is she's going to have to go to the court and seek guardianship and conservatorship for her husband. So a lot of people aren't familiar with the terms, and that's okay. Guardianship is to have authority over someone's daily life and their medical decisions. So you manage everything except for the money. The money is managed under the conservatorship. So yes, you can have one without the other. It's really uncommon to have a conservatorship without a guardianship, but it is fairly common to have a guardianship without a conservatorship. Because a lot of times we have young adults, maybe even like your children, who they turn 18 and maybe a guardianship is appropriate for them, but they don't have more than $10,000 or $15,000 in their name. In fact, usually we don't have anywhere near that. And in that point, as a guardian, you can manage up to $12,000 on behalf of the ward. And the ward is the person over whom there's a guardian. So a ward is the person who has a guardian, and then the person who has a conservator is either a conservatee or a protectee. It means the same thing. So that's...
So if we take it to a nuts, can we use you? Okay, what's your name?
Carrie,
Hi, Carrie. And you have a child who is approaching,
she just turned 18.
okay,
And I have another child that's 19.
okay. So this child that's 18, do you have a power of attorney or a
No,
guardianship?
that's why I'm here.
Okay. Well, we picked the perfect example. Now, the downside of asking lawyers is they'll give you legal advice. You're not getting a confidential setting. Okay?
It's okay.
So, yeah, I think that's a perfect example. Go ahead, you guys. Ask her some questions to figure out which way we would go.
Okay.
Well, we always start with asking questions to see if a young adult can sign a power of attorney. Because if we can avoid the court involvement, because there are additional burdens that go with that. You have a judge that's overseeing things. You have an annual report that you're going to have to file. There's one over the guardianship. How is the person doing? They still require a guardian. And there's the one where you have to do an accounting if there is money that you're managing. So if you also have conservatorship, you have to account for that money to the court. It's not a terrible thing. There are a lot of times when guardianship is helpful. But where we have someone who can sign a power of attorney, I find that that's usually better if we can go with that, because it just gives you more flexibility. Do you want to kind of talk about so I don't hog the conversation
that's okay.
about how we determine if someone can use a power of attorney?
Sure. Generally, we just have we start by having a conversation and just see how we interact. Would your daughter understand about money? Does she understand? Does she have accounts? Does she understand that by signing this, that mom and dad would be the ones managing her money? And just, we don't ask who the president is, or, some questions like that you may see more in a different setting. But we do talk to them and make sure that they understand that they're giving you permission to manage their affairs for them.
And when she turned 18, we had that discussion. She can sign for herself,
Mhm.
and she does. She has her own bank account. She has her own check. She can use a debit card. And we had the discussion when she turned 18, because I was trying to fill this out, and she said, I would like a little bit of help with the money part.
So, so she
she
clearly understands.
She has goals that she wants to do it. She did just verbalize that, yeah, I still need help with that.
Yeah. Well, and just in general, by giving someone authority as in a power of attorney document, you're not giving away any power. Oftentimes people think, well, if I sign this, especially sometimes some of our older clients may be fearful if they name one of their adult children as power of attorney, that they're giving up control of their finances. That's absolutely not it out. You're still in charge. It's still your money. It's still your account. You're just saying, this person can handle this for me if I'm not available to, or sometimes I don't want to, or I need some help.
I don't like the knee-jerk reaction in our culture. Oh, you have Down syndrome, you must have a guardianship.
That's
It offends
exactly
me.
how I feel.
So I have to put down, I get offended very easily, it seems lately, might be age and blood pressure. But it's because I appear to be challenged, therefore I can't process. This is a community we have a huge range of functionality within our children here. There was one of our early morning speakers who was sharing with you openly her IQ and her ability to function. In my opinion, I have only listened to her for a few minutes, is she's not a candidate for guardianship. She does not need to go to a court where she is represented and her parents are on the other side of that, where we're saying she cannot make decisions. What is her alternative? To have nothing gives me the goosebumps. She needs Lisa's solution, a power of attorney. One for health, one for finances. I wish we were further along and I could come to you today and say, we have finished the current law that we're trying to fix right now to allow for supported decision making. Have you guys heard of it at all? It's this new rage. It's not new, but it's great that it's coming. It's actually in draft form now. Supported decision making is a hodgepodge, a combination of using a power of attorney and using a guardianship process. It's your daughter saying, I can do X, Y, and Z by myself, but I want your help. I want your support with these other things. It's coming. It's not here. In the short term, your decision has to be very black and white. And if you have children in the school system, you probably lean heavily towards guardianship because of the IEPs. Because the door to you is closed when they are 18. I got a heads up, yeah. You are just hopefully in a good relationship with the school. And they'll say, hey, your kiddo's coming up on 18. They're going to continue through 21. We won't be able to talk to you anymore. So they're not super comfortable with the idea that it's a power of attorney because they've been told, knee-jerk, Downs, you need a guardianship. Not every child is the same.
Question about the guardianship.
Yeah.
You said something about a $12,000 limit. What's that?
The $12,000 limit is, the law says, and this is true for Missouri and Kansas, that if a person has $12,000 or less in financial assets, then the guardian can be given the authority to manage that money on behalf of the ward without having a conservatorship appointed. And what that does for you is it gives you those conservatorship powers over that $12,000 or less, but you're not having to file an annual accounting with the courts because we're not dealing with large sums of money. And there's not usually a lot of money coming in or going out at that point.
That's the ideal.
Yes.
And what we would want is to have just a guardianship and then have access to assist with Social Security, perhaps with a representative payee. One thing that was, I'm taking them off their target for a minute, but one thing that was mentioned in the last session was there's a lot of Social Security questions. And there was, should we go, should we not go? I have a do not stop mindset. Do not stop with the limitation. Do not stop with, I'm not sure if I want to go to Social Security. Go. Please go. Because I don't want you to be what our clients are like, where they have died and left us with an adult who doesn't have a label. The label's offensive. I get that. It doesn't limit you, but it does trigger these Social Security ones. The DAC that they talked about, if you aren't getting a disability determination before the age of 22, there's no DAC for you. Okay? So when you're wondering, do I do it? The answer is yes. And there was, yes, it is good to get Social Security. Does it automatically need to lead to Medicaid? It's state specific, and we have 2 abutting states. They handle it differently. Kansas says, oh, Social Security, yes, Medicaid. Missouri says, oh, Social Security, go find your way to Medicaid. So they're not the same. But
So
what if
we change the state from Kansas, Missouri to any other state?
you have to know those state, so SSI is federal, okay? So is there a federal, every special needs attorney needs to know the federal law, because it's the same across the board. And Social Security is federal. And yes, there are almost 60,000 pages to what is called the PALMS, which is a manual for Social Security. But you don't have to read that. You can do a little Google search right through it. But it used to not even be online. So it isn't an easy area of law. But the things that we need here are actually very simple. It's not so complicated. It is, you hit 18, you need Social Security to say that you have a disability in order to trigger future benefits. You don't have to take benefits now, but we need that pass. It's a whole pass. And you pull it out when you need it. And it's a trigger to, who knows whether you'll need early Medicaid or Medicare. And we could talk about that forever.
So, and like she says about the power of attorney for medical or finances, so you do not have to use that card unless they're asked to, right?
It's a metaphor. It's not a physical card, just so I'm clear.
Yeah, it's a letter, kind of,
Yes.
signed paper document.
So if I were in charge of Social Security, it'd be a card, right? You could pull it out. Your question is, do we need, tell me again, I'm not sure I follow.
Suppose I go to a doctor's office for my son's shot, and he says, no, I do not want shot, and I want him to get a flu shot. And doctor is not going to give because he's 18 plus, unless and until I show them that I have a durable power of attorney.
That's a great question. That's not the answer that you're going to want to hear. You guys want to take that?
Sure. So just because you have that your son appointed you as his healthcare power of attorney, that doesn't mean you can override his choices. So he's still in charge of his medical care. You're just able to convey his wishes and communicate with the doctor, and the doctor can also talk to you about his private health information. But if he says, I don't want the flu shot, you can't, the healthcare power attorney is not going to
Yeah,
have the doctor
because
listen
if
to
he's
you.
incapacitated, then only I can make the decision.
Right.
Right.
So what about if I get a guardianship?
So
Then you can say, yes, if I am your guardian, I can make you get the flu shot. I think at that point, you know, there's other factors involved in whether you force them to have the shot. But this is a pretty simple example.
Yeah.
So
Because
presumably
that's
this
what
is in his best
came across
interest,
the
and it's
first
not a
day.
big deal.
The first day he turned 18, next day I took him, he had the flu shot appointment. And he clearly said, no, I do not want a shot.
Okay, so sometimes I'm just going to be an ugly mother here. I have these 4 sons too. You just tell your children what they need to do.
Yeah,
Yes.
because I speak in a different language which other people
I
cannot
speak in the language of you're going to do what I tell you
So
to
I
do.
I tell in my own language, you are getting it. Otherwise, if you are an adult, then you are doing all your laundry and dishes yourself.
Yes.
He got the shot. That was the easy way out. Did he get it? Yeah, he got the shot. But still, I was worried because that was a small thing. What
Right.
if he needs a surgery? What if he needs something else?
Right.
So that
Well,
was
that's
my
a
fear.
pivotal life lesson for all of us is people are free to make poor choices. Just because you have a diagnosis doesn't mean you can't make poor choices. We get this all the time all the time. We don't, as parents, get to continue. It's my idea, perhaps I shouldn't be offensive. I didn't want my niece to get the tattoo, and so you saw that in my face.
Yeah.
But you might love tattoos, right? You may be covered in.
Yeah, you yourself have a tattoo. How can you say no to your kid, right?
Well, we all have different views, and they may not be the choices that we want, but we do want them. And so that conversation is often an hour and a half with your lawyer, trying to figure out the dynamics of your individual circumstance. If you give your child the autonomy that this child is not a child, excuse me, your 18-year-old adult, are they going to misuse that, and is there potential harm for that? I'll always remember my mistakes. You know, your mistakes, they sing with you, they talk to you in your head all the time. And I had pushed a woman to get a guardianship for her son because he had special needs. And in my head, this was the way. And this child lived alone, and even though she had guardianship, it was her life with him was full of struggle. He picked bad friends. They would come over and take all the food out of his fridge. She would give him freedom with his Social Security check, and it was still gone. And she was calling me, wailing and sharing her pain. The guardianship does not fix that. It's not the answer for all things. It's a legal tool that helps you in certain circumstances like school and like medical circumstances. So Nikki, tell us what the timing and the process, how much lead time do we need? We want
Okay.
this.
So ideally, if you have a young adult who is about to turn 18, it's helpful to kind of get the ducks in a row to file guardianship or conservatorship in advance of their 18th birthday, if you're wanting that to hit after they turn 18. So we can get a petition ready. We've got to have an evaluation from a doctor who says, yes, there are reasons why this person requires a guardian. And then we can get a petition that's going to the court and saying this person needs a guardian and I would like to be that guardian and here's all the data that the court requires. And then if we get that signed and have our ducks in a row, we can file the case in Kansas and set the hearing shortly after the 18th birthday. And then you've got things pretty well lined up. It's a little more challenging in Missouri. Sometimes we have judges who will let us file ahead of time to try to get that hearing close to the 18th birthday, but in Missouri sometimes we have judges who won't let us do that, and you've got to file at 18. And it takes a little longer to get a hearing, particularly in Jackson County. The other counties you can get into court a little quicker. And that can be done probably in 2 to 3 months. On the Kansas side, it's really a matter of about 3 weeks. You know, you maybe need another week or two for the legal paperwork to get everything in order. But then when you file the case and get a hearing set, that's typically done 2 to 3 weeks out from the case being opened. So it does take a little bit of preparation. And some doctors are amazing and they get us that doctor's evaluation really quickly. And others, it's like pulling teeth, and I have cases that end up open for a long time because we're trying to get the paperwork. Maybe we tried to get a hearing date knowing we were going to get this from the doctor, and it takes longer than we wanted. So But in most cases, it is very straightforward. It is very simple. It is not overly burdensome, and it's something that we can plan for. So it's a good idea to come in and meet with an attorney, you know, maybe 6 weeks or a month out from their 18th birthday.
Well, that was what I was going to say. How much lead time would you suggest?
I would say 6 weeks, then you're giving yourself lots of time.
But it's not too late if it is already 18, you can
Oh, no, you can still do it.
Is there any cons of getting a guardianship?
Yes, there are costs associated with the
No, not
guardianship.
the cost, cons.
Cons.
Against.
Yeah, against
Oh.
guardianship. Why we should not take guardianship?
Well, if you need a guardianship, then I think the guardianship is always worth it.
Worth it?
Worth it, because if you need it, you need it. And
So,
the
but
guardianship
you-
itself is not burdensome. You'll have an annual report to file, but it's a form from the court and you're going to know all of the answers. A conservatorship is a little more challenging because there is a big accounting that you have to do every year. But if you prepare for that and you're keeping good records from the outset, then you're prepared and that can be done and it's not so terrible.
No, because recently when my son was born, everybody says as soon as he turns 18, you should take a guardianship. And as soon as he turned 19, everybody started saying that guardianship is not the only way. You can go the other route also. So I want to know
Just
whether
go one of
taking a
those routes.
whether taking a guardianship is a good thing or not.
Yeah, and we could talk about this for 3, 4, 6 hours. Is it a good ship? Is it a good, guardianship or not? But the not is the power of attorney, and it's a court process, in my opinion. So that's intimidating, and it's lawyers on both sides, right? So you file it, so you hire a lawyer. Your son has to get appointed a lawyer. You are in front of a court. Raise your hand, swear to tell the whole truth. Tell me about your son. It's intimidating. So there's the lawyer cost, there's the fear factor, and there's the time that's required, and then the reporting. Yes, sir.
One thing, our daughter's turning 18 in a year, and we've started having these conversations with our folks. We're in Columbia. We're looking at power of attorney first, and what they have suggested, and I think when you're talking about the cons of a conservatorship or a guardianship, they have said is that it's easy to take the steps up to that. It's really hard to come back down. So if you had a guardianship or something like that, and he's doing really well, and you're like, oh, well, I don't really need to do all this. Can I peel off some of that? We've heard it's like almost impossible to. Or it
Not
can be
impossible
really
to
difficult,
peel
but
back.
like
You just
power
the
of
same
attorney like that.
process.
Yeah.
Go ahead. Were you going to say?
I mean, if you want to peel it back, you just have to go back to court with an updated doctor's letter. And again, the attorney for your child would be appointed to make sure what you're telling the court is accurate, because the judge sees you for 15 minutes. It's just a safety measure for the person involved who needs the guardian. And you file a petition and you get it set for hearing. And if you can document that, your child now can make more decisions on their own, then you can take it away completely. In Missouri, they have the idea of a limited guardianship. I don't see that working in practice a whole lot. I know that it can be done.
Your original comments at the beginning of this were, we've got a wide range of folks. Guardianship's not always the answer. So when you default to that not you.
I think
but
it's ignorant.
a person, when
I
a
think it's
person just
ignorant to
says,
say
okay,
your kid has a
right.
disability. You need to line up the lawyer at 18.
Exactly, right.
You need to line up the lawyer at 18 to have the conversation.
Right.
And the starting point is the power of attorney, which
Right.
you should have for your spouse, you should have for each other, you should have for your typical children at 18.
Right.
And then you decide with your legal counsel, is
How
it
far
a
out?
good idea?
Right.
How will it help you? And that's my whole hope in this, was just, it's not automatic.
Right, so the pros and cons are going to be different for each family.
Exactly.
Right.
Yes.
Okay, so we have been planning on power of attorney through this whole time, but you made a comment about the school that I went, oh my gosh. So like, if she becomes the person who sets her own goals for super senior year and second super senior year, and she could still invite us in, couldn't she?
Absolutely.
Yeah,
So you
yes.
preemptively have a relationship with the school. Now, often these schools relationships have formed and they're wonderful, and sometimes they're contentious. The need to digress into my own personal circumstance with the children I won't do it. But if you get more bees with honey, right? So I would go in preemptive and say, we are going to get a power of attorney. We want to make sure that we are invited to everything and that you feel with your particular school system if that will work. If you're seeing that it's just they're not going to get it, then you have to consider that and go the guardianship route, because you have to be an advocate until, and then you could back off. Then you could go back into court and say, we don't want to be the guardian anymore. What will typically happen is at the age of 18, you need to go to SSI. There are these steps, these basic steps, so the basic planning steps. 1, evaluate appropriateness of the durable power of attorney versus the guardianship. 2, walk into Social Security with your appointment and get the determination of disability. Does not mean that you will be getting their $941. It means maybe. Walk in with a lease arrangement with your child. As weird as it sounds, your child will not get the full $941 unless you're charging them. You charge your children with a standard lease. You don't need a lawyer for it. You have seen them on the internet. It's not rocket science. You need a lease. I'm going to charge you $550 to live in my house. Don't put the room and board, don't put the laundry on there. You'll look a little bit goofy, but I know we all do it. But you've got your fee, because otherwise your $941 is reduced. So I see families, they come in and they tell me their children are getting the $500 amount from Social Security, and I say, write up a lease, charge your kid, sounds weird, charge your kid, go back to Social Security, automatically your kid's money goes right back up. If your child doesn't have a whole lot of functionality with money, you're going to want to be representative payee. That's the term that Social Security uses, rep payee. You are just then going to have a bank account as rep payee into which their direct deposit will go. It's not that hard. You get your little Social Security letter, you go open an account at the bank, they're familiar with it. This bank account should never go above $2,000 if we want Social Security money. Yes?
Go into their ABLE account.
Not everyone can have an ABLE account. Yeah, so ABLE is the federal name for it. Missouri calls theirs the stable account. They are really easy to open. I mean, your children can open them. They can do video games. You go online, you open it up with $50, you have an account. The reason these accounts were created was so our kids could save money, not so that we could use them as tools. We should be using special needs trust. If you guys are funding ABLE accounts, it's because you don't understand why they were created.
To get the cancer state tax benefit.
Well, you can also, if you have other children, what she's saying is there's a 529. So that there is someone who's talking just about the ABLE, so I don't want to steal their steam, but I love the account. I love the idea of the account. Yes?
I do have a question now.
Oh, please.
A little bit about ABLE. If it goes over 12K, then we should go into conservatorship, right? The way I read.
You're saying if, do you want to take that one?
If the child has more than $12,000, is that what you're asking?
Yeah,
Yes.
in the ABLE account.
So
'cause
if-
it's in their
Oh,
name.
no, that's different.
Yeah,
Go ahead.
it's different.
Okay, good.
So the ABLE account is it's a it's a bank account,
Yeah.
right? But it's not going to be accessible to the child. So it's not part of their money. It's meant it's not going to require you to get a conservatorship.
Okay.
If that helps.
Can it count against like college scholarships?
No.
It can't. Because 529
Yeah,
can't.
it's 529A. It's an extension of 529 plan.
So I don't know whether individual colleges will say you have money in an ABLE account, we won't give you anything. I think that's going to be college specific. I don't know that that's going to be federal, but I
think
can't
so,
speak
they
to that.
take it.
Can I ask you a quick question back of the power of attorney? I looked online, and for Kansas, there's like a form that you can fill out, and it just like is very basic, and you go have it notarized. Like, if I can't get to you right now and I don't have money to like go, would that get me by for a month?
Yes.
I mean,
So-
I feel like now that we're 18,
I
How
know what you're
negative you
looking
are.
at. No, you don't feel panicked. Just about every estate planning attorney can do a power of attorney. Okay, the form online, we could find about 50 of them right now, so we don't know what is in it. Some of them will be what Lisa mentioned, and I'm hogging the time again. Springing. You tell why you think the form's a bad plan, Nikki.
Well,
Is it better to have nothing until I can afford an attorney, or?
Well, mileage really varies on the forms, and so it matters how they're written and what they say. They may not give you the authority that you need immediately. Most forms I find that come in from the internet are springing. Most springing, that means that they're not effective until the person is deemed to be incapacitated.
Okay.
And so you have to have doctor's letters showing incapacity for them to even be practical for you. And that's not something that we want if we want to sign an updated power of attorney down the road, because now you've got an incapacity diagnosis where we can't as easily do a new power of attorney.
So in the short term, your answer is painful to us, right? I want you to have it. So go home, look at these forms, and find one that doesn't say you don't have power until an event. So that's one thing to look for. Another thing is to look for a person and a backup. You need a person and you need a backup.
So like me and then my husband.
And then you need a notary who is not you guys, who has to notarize your child's signature. So there's how many more things can I tell you? Make sure it's financial and medical. They should be separate documents. So you need 2 different forms. They have different powers. They go to different people. They are different creatures. What other quickie things to make sure they get if they're doing it on there?
I will say in the Kansas City metro area, there are a lot of doctor's offices that provide the form for a medical power of attorney and living will from the Midwest Bioethics Center.
And I like
They changed
that.
their name, I can never get it right. And those are not as thorough as ours, but they get the job done. So for medical power of attorney, that is something that is usually free, and it is certainly better than nothing.
So the 1-pager, okay, let me just give you my little 2 cents. It's a 2-pager. On back page, scratch that thing out. It's a piece of bioethics healthcare form you can find online for healthcare. The 2nd page, exit out. 1st page, you're okay.
You just want the healthcare power of attorney.
So I hate the idea that you know you can't get everything that you want for free. That's why we're trying to give it to you. I mean, I don't want to be, oh, you need us. No, that's not the
One
method.
quick question for the guardianship. You said that for Kansas it's easy and Missouri it's thin. That means the guardianship is state-based? So
Yes.
if you move out of state, what
Yes, if
happens
you
to the
move.
guardianship?
Yeah.
You have to
Yeah.
move it to the place where you're living now. So the guardianship is in the county and state where the adult lives, the adult who is your ward, the person who you're guardian over. So if your family moves from Missouri to Kansas across the state line, once you're settled and you've been there for a certain amount of time, then you're going to open a new guardianship matter and have it transferred from here to here. So yes, it is located where you reside now.
So that means even if within Kansas, if I move from my county to another county, I still have to get it?
That's less of a hassle because you're just changing the county. So it's a little bit quicker to do that than moving state to state. It's not that hard. It's not that hard or burdensome.
Another
It
paperwork.
requires more paperwork.
But think about what you're doing, really. Why are we doing this? It's because you birthed someone who we've identified as needing additional attention, right? So we don't want to take away their rights, but now we've identified them as needing special attention. You will die before this human, hopefully. And now we want to say, hey, somebody else out there is a guardianship. We need to have someone in line. So you can't just move him, or you just, I don't like it when people steal people, but we get these stories of the stolen kids and the stolen adults, you know, where the one child comes in from Pennsylvania, sees mom has dementia, says, coming home with me, puts her in the back of the car, and nobody can find her. Those same processes that's the exact thing that we're dealing with here. Guardianship is a court process that says this person needs someone. So it's 2 steps. They need someone. Step 2 is who it is. And so it's,
And guardianship, like you said right now, for power of attorney and all, you should be one person and then you should have a backup. So the guardianship also has the same thing?
Nikki?
Yes, so you can be co-guardians with your spouse.
Yeah.
So
But
a lot
what
of parents.
What happens if me and my husband in a car accident and we
Right.
both die? What
So,
happens to that guardianship?
whenever possible, if we have another adult person who we would trust to take care of our ward, then we're going to name what's called a standby guardian and standby. And so if you and your spouse go on vacation, we have someone who could step in if there's an emergency.
How open, Nikki, have you found the courts to allowing parents to be co-guardians?
In Kansas, really in any court, it's a matter of if you're married, they will allow you to be co-guardians without a lot of questions, because presumably you are still able to get things done together. Where we have, it's not a definite. Where we have a divorced couple, that gets a little stickier. If you are good co-parents in the state of Kansas, you can present to the judge, we actually get along better now than we did before. We are able of managing our adult child together. Please let us be co-guardians. That can be done. I gotta say, I don't see that as the norm, but it certainly can be done. In Missouri, that's a harder sell. On the Missouri side of the state line, they tend to say we want one person to be the guardian unless you are married parents of the ward, in which case you can be co-guardians. But that's where we can have a standby. So there's someone else who has letters of authority who can step in the event of an emergency. And then they have to go back to the court and say, oh, something happened and I have stepped in. But they have the authority to do what needs to be done right then in the moment.
Nikki, you have a question on the wall, lady.
Yes,
with a hand
hello.
raised there.
Hi, yes, I have a question. So, I have a 16-year-old son. His dad and I are divorced. We're both remarried. We were, here, our divorce was in Johnson County, and then his dad is remarried and lives in the state of Arkansas. So we currently have a special needs trust, and we have a power of attorney, my husband and I. But if something were to happen to me, I'm assuming the state of Kansas is automatically, even though his dad hadn't until last year seen him, in over 7 years, they're automatically going to give my son, even though like my husband is the one pretty much, doing everything, all the doctor's appointments. I'm assuming they're automatically going to give it to his dad.
How old is your son?
16.
Okay, sorry I missed that if you said it. Yes, until your son is 18, the presumption is that a parent who has legal rights to their child is their presumed legal guardian up until the age of 18. But there are things you can do to prepare for that. So
I'm probably more than likely going to have, in his circumstance, like I know about supported decision making, I would love to be that, an option for him. I feel like he's predominantly nonverbal, and as far as, the medical and stuff, like I'm more than likely going to be applying for guardianship. I've already kind of contacted our attorney. And so in that case, if I were to apply for guardianship, I think she told me that since we're divorced, like his dad doesn't actually have to be like co-signing.
Unless you could terminate his rights. I mean, if he hasn't seen him for 7 years, termination of parental rights and adoption by the new stepdad sounds very appealing.
We've had a discussion. Unfortunately, I still get child support and everything from his dad.
Well, then don't do that.
My husband legally adopting him.
Sorry, it sounded a bit
That's what you were
mercenary.
saying.
didn't it?
Everybody has different.
Right.
And we have two other younger children as well, 8 and 10 currently right now. But I don't think that my husband wanted to legally adopt him.
okay.
So I just didn't know. I'm just really concerned if something were to happen to me. His dad doesn't know all of his all the medical stuff. And so that keeps me up at night.
Right. Well, when he is 18, I think you have a case that you could make to the court that you and your current husband should be co-guardians, even though your current husband is the stepfather. Now, his biological father has to be notified of the hearing, but he may or may not show up to have anything to say about that. So it may well be worth an effort to try that. But certainly there are things that I would do to set your spouse up for success versus biological dad if something happened to you.
So Nick, oh, sorry, go ahead.
If you have a durable power of attorney, medical one, for your son, does that include a living will kind of stuff? Okay, so how do you get that? My wife has a living will, I have. How do we get that for our son?
Well, Lisa, why don't you explain the difference between a living will and a power of attorney?
Okay, so a living will, also sometimes you might hear them called an advance directive, is a document that you are saying that in the event I'm in a persistent vegetative state with a terminal illness. So basically, you are not able to communicate at all. There's no indication that you can communicate. You are terminal, and you are being kept alive by artificial means, whatever those means might be.
How do we get our son to say, this is what I want?
Well, if you have a conversation with him and talk about if that is what his wishes are. You know, it's a very, depending on, how he feels about it and what he understands. But we take it very seriously when we draft these for people, and then when we have them executed, signing, executed.
You're killing it.
Yeah. I'm sorry?
They can draft it with his signature saying, I want to do the living will.
Right, and we have 2 witnesses and a notary that are there when that is signed. But again, it's a very personal decision whether someone wants that or not. So we take it very seriously. We talk to the person and make sure they really understand what they're signing. And also if it's a young lady, we have to also consider putting in what's called a pregnancy override in the event that something would happen while you're pregnant.
Right, that's
and
a
you're
depressing topic.
vegetative
Thank you very
state.
much.
And it's a
Let's
lot
just
of,
moving
it is
along.
very depressing, but those
Yeah.
are things to think about.
But it is a document we prepare with powers of attorney,
Mhm.
which may be the question. Part of what you were asking is that it is a document that we would evaluate whether there's capacity to sign. And if you have capacity to sign it, then it's another document that
And
we
if he
do at the
doesn't
time
have
of powers of
capacity
attorney.
to sign it, it could still get evolved in some respect.
I'm sorry?
If he doesn't have the capacity to sign it, that living will.
You asked a really mucky one. He's basically asking what the court's going to do about termination of
Well,
life.
if he doesn't have capacity to sign it, then at the time that you would be facing an end-of-life decision, you're looking at a guardianship where you have to get letters from physicians. In Kansas, it's 2 letters from doctors. There's a specific form for it. To go to the court and establish the fact that there's nothing we can do for this person.
You have to go to the court with something like that.
You have to go to the court with something like that to get a judge's signature saying, yes, termination of life is appropriate.
If you're already guardian.
Even if you're already
If you're
guardian.
already guardian, you don't have the right to withdraw life support without a court order, but it's not that hard of a thing to do. You just have to get 2 doctors to sign off on it, to take it to the judge and say, unfortunately, this is where we are.
So Nikki does well in court, and I hear court and I go the other direction. So in our practice, I lean towards the special needs trust drafting, and I just feel like I walk into court, my IQ lowers. So I let her go. Get better at it. But it's, yeah, go ahead.
I was wondering, on your slide it said that it is the guardianship is more conservative or restrictive than a durable power of attorney. And what are you referencing as far as that?
Okay, so with the power of attorney, the person who is signed the power of attorney is still able to do things for themselves. It's just we've named an agent under power of attorney who can go and also do things for them. As long as they have capacity, they can still act though. If you have guardianship, you've taken away their legal authority to do things for themselves. So the
it's more
guardian,
restrictive for
it is
the
more
board.
restrictive because
Correct.
you've taken away the ward's authority to do things for themselves. And it does give, the guardian has more power. So as we were talking about the flu shot, the guardian can make them have a flu shot. The guardian can say, no, you can't go to the airport and get on that airplane. Whereas a power of attorney can try to talk you out of it, but when they're standing at the gate, you can't prevent them from getting on the airplane. Which comes up, rarely that we have somebody who's a flight risk, but that's unfortunately a case where we would want a guardianship.
And the practical matters, the day-to-day practical matters lean more towards the IEP and the physicians than to anything else. Or I've heard situations where your children move into group homes and the group home administration doesn't respect the power of attorney authority, and so because of the logistics of life, you end up feeling that you're in this more restrictive route and it bothers you, but you sometimes have to do what you have to do to get by.
Right, and you can take the legal authority away from the person, but a good guardian is going to talk to their ward, and you're going to let your child participate in the decision-making process with you. That is part of supported decision-making. It's just not supported by any laws. It would just be the actions of a good guardian, in my personal opinion.
And that's why the law is a bit kind of squishy. The
Right.
supported decision making is just this law that's trying to get the guardians to take the view of the individual that they're working with. What was your question?
Is there such a thing as an educational power of attorney?
You can create any kind of power of attorney you want, but I would say that someone's trying to limit it to a specific thing, right? They're trying to say, my guess. So considering that I've been a lawyer for 30 years and I haven't seen one, I'm going to say I don't think it's normal, but could someone create one? Sure, and it would look like educational power of attorney. I, Samantha Shepard, give Lisa authority to make my education decisions only. Sign, sign, sign. I mean, you could do that. Whether it will, is it normal? No.
It's worth a try.
No. Sorry, I'm a really opinionated girl.
Can you please clarify that living will thing again?
Yes,
for the
there are,
special leave case?
there are 4 documents that every human needs at 18, and they all end at death. A power of attorney for health care, which should be power of attorney for health care, a power of attorney that covers financial things, and called a durable because it lasts through incapacity. A HIPAA document, which is authorization to see your child in the ICU, authorization to get your husband's medical records and see his sperm count. I'm just saying. But the HIPAA is pretty invasive, right? You can see all their medical. And the last one is what Lisa was talking about, the advance directive, also called a living will. Those 4 documents, all of you individually should have. Those are the basic tenets of your estate plan, right? But everyone should have those. Did you want a question, or did you just have an itch? She just had an itch. Beyond that, let's go beyond that now. I got a little note from Sarah that lunch is delayed so that we don't have to rush. So our time is actually, we really had focused right on giving you a very concrete lesson, guardianship versus power of attorney. Does anybody have, before I go, I love to talk about special needs trust. Do you have any questions that you feel are still unanswered about guardianship? Yes.
If you have a guardianship, you still need a HIPAA and advance directive?
No, because the guardianship gives you that authority.
Both of them?
Both of them.
I don't have to worry.
Okay, yes ma'am.
You've done our special needs trust, so thank you. But
You're welcome.
the previous speaker said that there were some changes since 2020 and ours is prior. I'm curious what has changed, and then if you could also.
I was
talk about-
wondering that also. So the special needs law is what I do for bread. I was going to say for fun and for career. And we've had some significant changes in the law that concerned retirement accounts. So Secure Act was one of them. You've heard about it a little bit. So when you come in to meet with a lawyer to talk about your estate plan, you're going to list all your assets. A lot of people have, hey Sarah, a lot of this is how you look. I'm going to point her out. This is the gal. We've had some able account questions. And I said, you know, we'll give you some, but I'm going to defer to the expert on that. And she has the whole history behind why it was created, which is kind of awesome. What other things have changed right now? So the IRAs and how they're handled with spouses versus special needs. In a nutshell, individuals who have been determined to be disabled, again, that's why we like that determination of disability, they still get to stretch. Not this kind of stretch, but the stretch meaning if you leave that person your 401k or your IRA, they get a unique ability to delay taking that money out and it still grows, tax deferred. Other individuals can't do that, just the spouse. Well, there's exceptions, we could go down the bunny path, but the general rule is married, you name your spouse on the 401k as your primary, and then you name your revocable living trust as the beneficiary. We look through the revocable living trust, we see that there's also a special needs trust. The individual with the special need gets that pot of money so they can hold it there and it grows tax-free until they need it. So that is a big change, and that has been, you know, I can't believe it's been 2020. It's too, in my head, it's still 2020, but that was, yeah, 3 years and change ago.